Hi, my name is Joe Di Bartolomeo. I'm an Oregon workers' compensation lawyer. I represent injured workers. I have offices in Astoria, Oregon and Hillsboro, Oregon. And my work that I do for injured workers is through the Oregon workers' compensation system. In today's video, I'm giving you 5 mistakes to avoid when you file an Oregon workers' compensation claim. The reason I'm making this video is that I see people when things go wrong. So usually my client has filed a claim. They may have been denied on their claim. I go through the claims file and I see certain things that if I were involved earlier on, I would have cautioned my client against. And so I'm making this video in hopes that if you've just filed a claim or if you're thinking about filing a claim, you can avoid some of these mistakes. Some of them can make or break your claim. Others just make it harder for you to get from here to there on a claim. So let's get started with the 5 mistakes that you can avoid when you file your workers' compensation claim in Oregon. Oregon workers' compensation is a statute, and basically that statute is an insurance policy that is imposed on employers in Oregon. And it basically says if your employee is injured on the job and they prove their claim, and it's accepted, you have to provide certain benefits to the employee. Now, before we even get there, the employee has to file their claim in a certain way and within a certain time. Now, there are all kinds of cases that deal with the issue of whether a claim was filed. And it is amazing when you look at the fact situations that come up and how complicated it can get. Nobody wants to get into that kind of fight. The general rule, again, these are general rules, is that if you suffer an injury, then you have to file your claim in writing within 90 days of the date of your injury. Don't wait 5 days or 10 days or 2 weeks. File your claim as quickly as you can after the injury. What I see, even when people file their claim within that 90-day window, is an argument that somehow the injury didn't occur because of the delay in filing the claim or the delay in seeking medical care. What I also see from responsible employers is the client or the injured worker reporting the claim to the employer, and the employer insisting that the client or injured worker get to a doctor or an urgent care to get checked out, and then the claim is filed. But don't wait. Don't wait too long to file your claim. Don't be a hero and try to work through it, because an insurance company may use that against you as a way to argue that your claim should be denied, or at least create a legitimate doubt as to whether the claim is valid. Now, if you have an occupational disease claim, and that's something that occurs over a long period of time, like carpal tunnel syndrome or hearing loss, or any kind of repetitive stress injury when you work with your hands repetitively, like a seafood worker or a pipe fitter, then you have a longer time to file your claim. You can file your claim within a year of the date that you knew or should have known about your occupational disease. And what I mean by that is you go to the doctor, maybe you're having a hearing loss issue, and your doctor says to you, you've worked at a plywood mill for 20 years, and you were there before they really paid attention to occupational noise exposure. This is related to your on-the-job noise exposure at work. Well, that starts the clock. So again, don't wait till the last minute. Now, that being said, I've had people who've actually come into me after they've retired and first learn about their occupational disease, and we are able to successfully pursue the claim. But there's no excuse for waiting. File the claim if you feel like your carpal tunnel syndrome, your repetitive stress injury, whatever it may be, is causing you to need medical care. So that's the first mistake that I want to caution you on, is waiting too long. There are a lot of ins and outs to filing a workers' compensation claim. And if you do file a claim, that starts a 60-day time period where the insurance company has the ability to investigate the claim and decide whether or not the work-related injury is actually a work-related injury, whether they want to even take responsibility and accept the claim. We call that the deferred status period. Now, if your injury is disabling you and that disability is lasting more than the 3-day waiting period, you need to get an off-work note, or the fancy term is a disability authorization, from your physician, from whoever is providing you treatment, so that you can qualify for the interim benefit. That means the benefit that occurs during this decision-making interim deferred status period for you to be off work. Because even if the claim eventually is denied, if you are disabled longer than the waiting period, then you would qualify for what's called temporary total disability, or it could be temporary partial disability, and you would get a full wage replacement benefit, or at least a partial wage replacement benefit. Now, when I say full wage replacement benefit, I don't mean that you're going to get every dollar that you lose because you're off work. You will get whatever the statutory or regulatory, what the rule allows for your time loss benefit. The other thing that I'll mention, and I should have made this a mistake that people often make, is that if you're working more than one job and your on-the-job injury disables you from both of your jobs, if you notify your insurance company right away, then you may be able to get what's called a supplemental time loss benefit as well. So job 1 is a 40-hour-a-week job, and job 2 maybe is 20 hours a week, and that's going on quite a bit. Then if you're knocked out of job number 2, and you must report that right away, and you can get what's called supplemental temporary total or temporary partial disability benefits. So get that disability note and report any supplemental income that you're losing to the insurance company, so you can get that wage replacement benefit, so you can get from here to there while the insurance company is deciding whether they need to accept or deny your claim. Let's move on to the next mistake. Most of the people that I represent, even in the situation of a claim denial, did what they needed to do to cooperate with the insurance company who was deciding their claim and who ended up actually denying the claim. But once in a while, we will see a situation where an injured worker doesn't follow through and cooperate with the insurance company that is investigating the claim. And I believe that an injured worker could actually be fined if they fail to cooperate with the insurance company. Let me give you just a couple of examples of where you need to cooperate with the insurance company. The insurance company is investigating your claim. And what that really means is that they're gathering information. And so they're going to send you a questionnaire. When you fill out the questionnaire, you should fill it out, be sure to provide them accurate information. Don't guess, don't speculate, don't omit or leave things out on purpose. Don't fail to provide them with information about a prior on-the-job injury. They're going to know about it in most cases. So that's one example. The other example that I see is where an injured worker refuses to provide a recorded statement. The statute says that the insurance company can request that you give a recorded statement. I have other videos that talk about how to get through those recorded statements, and you can check that out on my website. I have ebooks that I offer. If you're looking at this on the website, you can check out the free information tab up here, and you'll find a couple of different workers' compensation guides that touch on that topic. If you're watching this video down below, or excuse me, on YouTube, down below, I will leave a link to the website and to one of my guides. But you want to give the statement. One thing to keep in mind is that if you hire a workers' comp lawyer to sit through the statement, the insurance company has to pay their fee. That's your lawyer, but they get paid by the insurance company. So that's kind of a good deal. Especially if you're dealing with a catastrophic, serious injury, you want to make sure you're probably going to be better off having somebody sitting aside you and watching what's going on to make sure everything's going the way it should. But you have to give that statement. Same thing with independent medical examinations. You have to attend the independent medical examination. And again, I have videos, I have articles on the website that talk about the independent medical examination. I have a survival guide that you can download that'll explain that process, but you have to go. Now, you do have certain rights and options. You have the right to object to the scheduling of the exam, whether it's too far away. If it's at 8 o'clock in the morning, 3-hour drive away, you can say something about it. You have to do it right away. In a lot of cases, you can have somebody present to observe at the exam, but you have to go to the exam. And that's part of that cooperation obligation that the statute places upon the injured worker. So let's move on to the next most common mistake that I see representing injured workers. I'm an attorney, I represent injured workers, but I'm also a business owner, and I've employed quite a few people over the years. And a law office is it's probably one of the safer places to work. But throughout the years, we've had people who have had on-the-job injuries or medical conditions come up because of the work activity that they've performed at the office. And what we'll get the call from the insurance company, one of the questions we will get is, do you have any concerns about the validity of the claim? And that's probably a fair question, because there are people who file claims that probably should not. We may disagree about how often that happens, but it happens. And what I've seen when I've represented injured workers is they will work or will be working for a smaller employer, a mom and pop type shop, and they know their employer pretty well, and they are concerned about how it would impact their employer by filing a workers' compensation claim. Now, more times than not, when the injured worker has tried to protect their employer, they end up regretting doing that. And here are a couple of examples that are just kind of things are firing off in my mind. It may be the injured worker going into the doctor and saying that they injured themselves somewhere not at work. And that does happen. And they're concerned about the employer having to be exposed to a workers' compensation claim or being sued, which can almost never happen. And so they go in and tell their doctor that it happened at home or something else happened. It doesn't happen a lot, but it happens. The other thing that you'll see is the employee waiting and waiting and waiting to see if things get better, and then finding out that they have a pretty serious injury, maybe they need a surgery, and then they end up finally filing the claim, which kind of goes back to the first mistake that I talked about, waiting too long. But the thing is, especially if it's a serious injury, you really need to look out for yourself. You need to look out for yourself, because if your claim is denied, you are not eligible for pretty valuable benefits like medical care, temporary disability, permanent partial disability. All of these are explained in the other guides and videos that I offer. Also, a big one when you're seriously injured would be vocational rehabilitation, where you are unable to return to your job and you need to find something else to do that will earn you a competitive wage that you can live on. If you are more concerned about your employer's welfare, you're giving up, potentially anyway, you're giving up some valuable benefits that will enable you to work and make a living down the road. So think long and hard about whether it makes sense to protect your employer, especially if you're dealing with a serious injury. Now, that being said, if you have a minor injury, the statute does allow your employer to pay for that. If you have to take a few stitches and they're offering to pay for it, that's one thing. But if you have an orthopedic injury that's disabling you in a permanent way, you need to think long and hard about whose interests you need to be protecting. I don't see it happen a lot, but I do see it happen. and it's something to think about when you've suffered an on-the-job injury. Okay, enough of that. Let's move on to the next mistake. I kind of already touched on the recorded statement because it is part of your obligation to cooperate with the insurance company when they investigate your claim. But I think it's probably good to talk about that a little bit more. On my website, I have the guide. I think it's called "I Just Filed My Workers' Compensation Claim, Now What?" or something like that. I can't remember the exact title. And in that guide, I get into some detail about the recorded statement. And I'll do that a little bit here, and then we'll close out the video. So when you give a recorded statement, and this is kind of what I tell people who I do injury claims and we file lawsuits and my clients are going through a deposition, which is like a recorded statement. It's sworn testimony. When you give a recorded statement, you have to assume that the insurance company already knows a lot about what happened, and they know a lot about you because they have checked you out. Believe me, they have checked you out. So rule number one, you want to be honest. It kind of goes without saying, but we need to say it because if you are intentionally dishonest, if you intentionally mislead the investigator, that's probably a death knell for the claim. I've seen it happen. Number two, part of being honest. All these other rules are part of being honest. Don't guess or speculate. If you don't know the answer, that's okay. If you don't remember something, that's okay, if that's your honest answer. If you can give an estimate, that's great. Number three, take your time. If you need to think about your answer before giving it, if the investigator is getting into great detail, perhaps about your work history or prior on-the-job injuries or prior injuries, maybe you were in a car collision 10 years ago, think about your answer before you give it. It's not a race. So, think about your answer and then give your answer. And those are just a few things to think about when you're giving a statement. Again, be aware that your statement is just one piece of the investigation. The insurance company has probably talked to coworkers, has probably talked to your employer, has your medical records, knows your medical history. So just be aware of that when you're giving your statement. And last of all, realize that this investigator, they're usually friendly. Most of them are above board in the way they approach the statements that they take. But realize that potentially this insurance company is in an adverse position to you. That's a lawyer saying they're on the other side of the fence. So they're not your friend. They're not there to help you. They're there to see if there's any way they can legitimately avoid accepting your claim. And I'm not being cynical. That's what they're doing in many cases. So that's my final mistake. Now, there are a few more that you might be able to make, but I just decided to call this 5 mistakes to avoid on your workers' compensation claim. If you have other questions, check out the guides. I'll leave links down here on the YouTube video. And if you're watching this on my website, there's a link up above. And you can check out other videos. You can contact us. I'll leave a link for that as well. If we're not able to help you, we will put you in contact with somebody that can, or at least give you some resources so you know where you stand. Thank you so much for watching the video. Take care.